Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Today I'm going to talk about a question I'm always being asked. My BRP is going to expire, whichever BRP you have, student visa, spouse visa, any other visa, and you want to apply for the skilled worker visa. However, there are various reasons for which you have not got a certificate of sponsorship yet. Can I still apply for the skilled worker visa without having a CoS, certificate of sponsorship? So I'll talk about the immigration rules, how what matters as per the rules, and what is possible, what is not. Yes. So first question to answer, the CoS, the certificate of sponsorship, it is mentioned in the validity requirements. So an application is not valid. So there are several validity requirements in the immigration rules. For example, you paid the immigration research charge, you paid the IHS fees, you have used a specific application form, you have provided your identity document, passport, etc. So, and you have provided a certificate of sponsorship that is written in the skilled worker appendix. But this is something that we have done in the past because what has happened is, I'll just give the background firstly. Before the skilled worker was started around after Brexit, so I think December 2021 or so. Yeah. So when the tier 2 general was changed to skilled worker, at that point the requirement of having a CoS was moved from eligibility into validity. So there are several requirements. So the first one that a caseworker or would look at is validity. If the application is not valid, it will not be considered. It will be rejected as invalid. So previously, when it was tier 2 general, the certificate of sponsorship requirement was in the eligibility. It was not in validity. So if you don't send a certificate of sponsorship, that was fine. Your application is still valid. It will be considered for a decision making, and then it may be refused if you don't give it till a decision is made. That was the case before. However, now the certificate of sponsorship requirement, it is mentioned in validity. The same thing has happened for the student visa also. If you don't have a CAS, confirmation of acceptance for studies, that is gone into the validity now. Earlier it was in the tier 4 general, now it was in the eligibility. So focusing on the skilled worker now, the CoS is under validity requirement, but we have been successful in filing applications without a CoS and giving the CoS subsequently. So we do represent employers also. There are various videos on employees, sponsor license, list of documents, everything you can find it. And sometimes it happens, the employer comes to us and says, oh, we want to hire this person. However, this person's visa is expiring in next whatever time, within next 2 months. However, the sponsor licensing itself takes about 6 to 8 weeks, and then issuing, applying for a CoS, and then applying, making the application. Sometimes the timelines don't match. So we have done it in the past where the sponsor license was in process, let's say, and we didn't have a CoS, and we still filed the application for the skilled worker visa, whether we are representing either the applicant or we are doing representing the sponsor or we are representing both, doesn't matter. So if especially we should be representing the applicant in this case, because the skilled worker application is of the applicant, not of the sponsor. So even if the sponsor license has been pending decision, etc., we have been able to file the skilled worker application without a CoS, ask the case working team to hold it. This has to be done very carefully. Don't do it yourself. We have done it successfully. Immigration lawyers can do it. So we have done it out of experience, I can say, where we have filed the application without a CoS, asking them to keep it on hold till a decision is made. We have a good working relationship with the Home Office, so I think every time it has worked out. I have never had any issues. None of these were rejected as invalid, where ideally they could have, because it's in the validity requirement. But yes, the applications are kept on hold, and once the sponsor license is approved, we give them the certificate of sponsorship, and then they make a decision on the application. Sometimes the CoS may be pending for anything. It may be for sponsor license, it may be the sponsor has got a license, however he doesn't have allocations. Sometimes they have gone out of allocations, the allocations are finished, annual ones, and they apply for the allocation. Now, it is given under priority, but the priority services are so full that hardly any immigration lawyers are getting it, or even individuals, it's almost impossible to get. So there are, I think, 60 slots in a day, etc., and they are used for various reasons, not just for costs, additional cost allocations. So it is possible that it may go up to 2 or 3 months to get a cost allocation, in spite of having, if it's already an employer has a license, they don't have the cost allocation to assign the cost to you. So in the cost you have allocation and then assignment. So if they don't have the enough allocation, they have to apply for an allocation for you, for the applicant, and then assign it to you. For that reason also we've done it. We've applied, we've represented either employers, usually employers and employees together, uh, where we have told the home office that we have already requested additional costs and asked them to keep on hold. So there may be various reasons why. It may be sponsor license pending, cost allocation pending, anything and everything. So we have been able to hold the applications and get a decision subsequently. This is just for information purposes. Don't take it as a blanket advice. The case working team has an option of just declaring the application invalid, returning it to you, and that's the end of it. You won't even have a section 3C leave if it is declared invalid. So that is a big problem, because by the time your BRP will be already expired. So this needs to be done very carefully, very, very carefully. Always do it through a lawyer. So for your specific case, do book a consultation with us and we can advise what is possible, what is not. But yes, this is possible overall. If you have a sponsor or an employer who's willing to give you the certificate, and it's just for some technicality, it is pending here and there, then yes, it is possible. We can apply for a skilled worker visa without a cause and keep it on hold and then subsequently get it sorted. Also, yeah, so it can be done either ways, whether you are filing on the Access UK application portal or you are doing it through the IDV app. So if you don't have any under 18 dependents, you would go into the IDV app and you would do it through that, not the IDV app. It can be done through the ID check app. I think that is the name. Yeah. So even if you're doing through the ID check app, the app application through the app, or you're doing the online form where you're going onto the computer, that's the Access UK system where you do a skilled worker visa application. So this can be done in either of them, doesn't matter. That is, these are just procedures. So that's it. This is what I wanted to cover. Is it possible to apply for a skilled worker visa without a cost? Yes, it is possible in this scenario if you know that you are going to get it in the near future. And every case is different. And for your specific case, do book a consultation with us. Don't take this as a blanket advice. It If they decide to declare the application invalid, the applicant is in a lot of trouble. They are without leave in the UK. They can't even continue to work wherever they are working. Their work rights also go to zero, even if they had any work rights before. As per the section 3C leave, as soon as it is declared invalid, that's the end of the section 3C leave also, if nothing has been done subsequently. So this is quite important. So we do it very carefully, do it through lawyers only. For your case, book a consultation. Do follow us on, do subscribe to our channel. If you like this video, give us a thumbs up. Click on the notifications icon. Yes, there are many people, yes, they have been contacted. There are many individual students who are switching, graduate route holders, visa holders who are switching to skilled worker, etc., who are stuck in the situation where towards the end of their leave, let's say their leave is expiring in next a month or so, and then now they found an employer, but the employer is struggling and trying to apply for a sponsor license to sponsor them, something like that, or any other situation. So there are many people in this situation. Please like this video, subscribe to our channel. In this way, YouTube will throw this video to other individuals, other students, other graduate route holders who are trying to get into the skilled worker visa, but only for the reason of not having a cause. They may be stuck at a point, because if you read the immigration rules, this is where you'll end up. It will go in the invalidity, and you may also get some advice from some lawyers saying no, it is not possible, but we have done this, so there is nothing. I'm talking from experience. So uh, yes, this is possible. It has to be done through a legal representative only, through an immigration lawyer only. We are qualified at the highest level, Office of the Immigration Services Commissioner level 3, advocacy and appeals. We also do appeals in the tribunals, first right tribunal, upper right tribunal. So we have experience doing all of this. And yes, you can apply for the skilled worker visa without a CoS and then take it from there if there are any challenges in getting the CoS. And that's it. Subscribe to our channel. Also follow us on TikTok. We also post videos on TikTok. And that's all from me for today. Thank you very much.